that because of the demonstration, but also because of the clarity of the argument in our brief that goes on the Hunter-Seattle doctrine, which I could say something about some other time.
Lo primero que quiero decir es que cree que la audiencia de hoy nos fue muy favorable, mejor de lo que esperábamos, y que cree que en gran parte es por la demostración que tuvimos y por el tipo de argumento que estamos haciendo en nuestro caso.
So, because of our rally and our overall case, and because the justices, the first person who spoke, let me try to make this clearer, was the Attorney General. And right from the beginning, and it was either the first or second question asked the Attorney General was from Justice Kennedy. And he asked, how is it that this case in Michigan is in any way distinguishable from Seattle?
All right.
So it started out with our opponents being on the defensive.
Good.
So que sí, que cree que la demostración que tuvimos ahora y el caso en general es en gran parte porque fue favorable, y que quiere hacer claro que cómo empezó el caso, que la oposición fueron los primeros en argumentar el caso, y empezando a hablar, uno de los jueces le preguntó al abogado que distinguiera cuál era la diferencia entre este caso y otro caso que se llama Seattle, que también está basado en lo que dice que una mayoría de blancos de un estado no debería de tener el derecho de decidir el futuro de miles de comunidades minorías. Y entonces que desde el principio que la oposición empezó en la defensiva y no en la...
And I think starting on the defensive pretty much for the whole time that the Attorney General spoke in what was his first part of his time, he was kept on the defensive. One of the things that was so pleasing to me about this hearing, and that made clear the importance of this hearing, and again, the importance of the fight for immigrant rights and our demonstration, was Justice Sotomayor was by far and away the most active judge in this hearing.
Y que porque el juez le hizo la pregunta a nuestra oposición y que ellos empezaron en la defensa, significó que por gran parte de su argumento estuvieran en la defensiva. Y que cree que por la demostración que hemos tenido, por la lucha que tenemos en nuestras demandas alrededor de derechos de inmigración, que la juez Sotomayor fue la juez que apoyó más el caso durante la audiencia hoy.
When the Attorney General was done, and I think it was clear both in his first speech and in his last speech that he has a very weak argument. And in the end, to be able to rule for him, you would have to retry the Grutter case in your decision and rule against affirmative action. And I think none of these judges want to do that.
Y que cuando la oposición habló al principio del argumento y luego al final del argumento, que fue muy claro que su caso es muy débil, y también que para que los jueces estén de parte de ellos, que la decisión que se hizo en el 2003, el caso que ganamos, se tendría que ser escuchado de nuevo y tendrían que votar en contra de acción afirmativa, lo cual no pasó en el 2003.
The second person who argued was Mark Rosenbaum, who was arguing for the NAACP and the ACLU and all of the establishment, civil rights, and other organizations. And he began where the questions had left off, which meant that he began by answering several of the questions that the judges had asked to explain and defend Hunter, and Seattle, which was a good start, and again, was our influence, or I think that would not have happened. The problem was, there were two things that he said, one of which I thought in particular Justice Ginsburg really picked up on and was important. First, that the Constitution, that laws that discriminate against white people or laws that discriminate against black people have to be treated the same. In other words, a colorblind Constitution idea, and support for the idea that the point of the 14th Amendment is to take race off the table. And I think those two arguments, I don't think that they were not helpful, for sure, but they were not arguments that any of the liberals were entertaining. And that was, I think, especially true because of the action and clear support for our case by both Judge Sotomayor and Judge Ginsburg. And Judge Ginsburg brought up a point that I didn't really have a chance to come back to, but was a core understanding of ours, which is, she said that originally this doctrine that says strict scrutiny, that says you have to really, really, really justify if you're the state. There has to be a compelling reason for you to create a racial classification and take action in order to ameliorate discrimination. She said originally that was something that was in our favor, but now it was being turned into something different, and that is absolutely the case. So that, I think, there wasn't I think the willingness of Rosenbaum to stick to Hunter Seattle and to argue in those terms was very positive, opening up the invitation to the right wing to use the concept of the colorblind Constitution to strike this down, I think was a real mistake, but I think it was not something that the liberals seemed the slightest bit inclined to do. I was the next person to get up there, and
You did great!
well, I did great because I'm in BAMN. And that adds more to my side than any argument I could make. I think what I did achieve, though it's hard to remember what you said under these circumstances, were two things. First, to make clear that our understanding of the 14th Amendment is that it protects minority rights. And to make that point early on, which completely woke up Justice Scalia, who had barely spoken, and he immediately said, "Oh, but that's against the doctrine of this whole court, yada yada yada. Can you point to any decision of this court?" And by that, I took to mean the court before us that agrees with what you said. And I said no. But what Justice Breyer did was come in and say, okay, but there are people who agree with you. And there are two sides of people who are still debating this question on the court. And there are people who are more on your side, and there are people who are more on the other side. But in other words, it isn't a dead letter. Because we haven't ruled that way doesn't mean that we've abandoned that understanding.
That's right.
So I think the other thing that I succeeded in doing was by the end at least making clear what the rule, what the two component parts of Hunter Seattle are, what the doctrine is, what it relies on, and what we are asking them to uphold. And I really feel, okay, there's no saying how the court will vote. But I can say this, that both in terms of the question about how is this court ruled, Justice Breyer wanted to step in and make a more balanced answer and provide some context for my answer that made sense. And then at a certain point in the questioning that Justice Alito was giving me about what level of government, if we went from the faculty to the dean to this to that to this one to that one, like when does Hunter come in? I was thinking to myself, well, the dean isn't that much bigger than the faculty, and it has to be something remote, but where would you draw the line at remoteness? So I was kind of stumbling along with the question, and then Justice Sotomayor interrupted me, and as Justice Alito said, answered her question completely. That meant that by the end, when the Attorney General got up again, Justice Alito asked him, well, do you think we should draw the line at a constitutional amendment? Like, if we have to draw the line somewhere that minority political rights have been taken away, have been overburdened, that there's a shift in the political structure, he asked the Attorney General, are you asking, or should that line be at a constitutional amendment? And that was a more kind of favorable question for our side than anything we were expecting from Justice Alito. And it was clear there again that what we intended to do in this hearing, which is to bring that left wing to life and to make them assert themselves. Okay, you could say that in a way, just having, last term, they were exactly 11 minutes out of 1,800 minutes of argument before this court that were argued by a black person. Only 11 minutes. Less than 0.006% of the time was there someone black before them. And I do think that in particular for the judges on the left, that was really important, that there was somebody who was up there and who was fighting, who really could speak for the movement and was of the movement and had a direct